Thank you. Please be seated. Good morning, Council. We're here for oral argument in case number 1 CACV 19-0467, Ronald E. Podgorski. Yeah, is that how you say it? Podgorski. In the matter of his estate, and petitioner being Raymond Podgorski versus Christian Jones, respondent. Council, thank you for being here this morning in these unique circumstances. Just a couple of procedural things that be just a bit different. Obviously, we're spread out a little bit, and we will do our best. Judge Williams will not have the benefit of a microphone, but he will, if you'll do your best to ask him if you can't hear, and he'll repeat the question, and also remind you that we are recording this and to the best of our abilities, audio and video recorded. At the beginning, each side will have 20 minutes, so at the beginning, if you'll please reserve as much time as you want for rebuttal for appellant's counsel. I don't know, do you plan on splitting time, Mr. Parker? Yes? Okay. I'll leave that up to you to decide how to do that. Although I'd ask you to only switch once. And the reason I say that is because what we're going to do, because after you sit down from being up at the pulpit by the podium, we're going, if you'll give us about 30 seconds to wipe that down, we'll do that and may just sanitize it a little bit before the next person gets up. So we'll do that each time we change counsel, okay? What else? Okay, so I'll also note that we've read the briefs, we've discussed the case in conference, and with that, counsel for appellant, you may proceed.
Good morning. May it please the court. My name is Colleen Thomas, and I represent the appellant Raymond Podgorski. This case involves the application of Arizona's revocation on divorce statute, ARS 14-2804, to a decedent's former stepchildren. The court must first determine whether the child of a decedent's former spouse is a relative of the divorced person's former spouse under ARS 14-2804. Because the answer to that question here is yes, the court must next then determine whether or not any of the statutory exceptions to the statute apply. Because the answer to that question in this case is no, ARS 14-2804 operates here to revoke any dispositions to or nominations in favor of the decedent's former stepchildren. I would like to reserve 3 minutes for rebuttal. Turning to the first issue, whether the child of a decedent's former spouse is a relative of the divorced person's former spouse, as that term is defined in subsection I-5 of the revocation on divorce statute. That term is defined in subsection I-5 as a person who is related to the divorced person's former spouse by blood, adoption, or affinity, and who after the divorce or annulment is not related to the divorced person by blood, adoption, or affinity.
Counsel, that's quite a mouthful, that particular definition, at least for me. But maybe we could start out by, I'd like to explore why, in your opinion, did the legislature include this second affinity word? Why would the legislature include the second affinity phrase, it comes right at the very end, if it didn't have some particular meaning? And if we assume that the legislature would have included it to have some meaning, what is that meaning under this definition?
Your Honor, the definition of affinity is a connection that arises as a result of marriage. It's a legal relationship that exists between one spouse and the other, and then the kindred of each of the spouses. In other words, it's step relationships and it's in-law relationships. And here we're dealing with the step relationship. So the decedent here is Ronald Podgorski, and his former stepchildren, Krista Jones and Douglas Olson, claim that they are entitled to certain dispositions under a will or a trust or a life insurance policy here, and also to certain fiduciary designations under the will and the trust.
Correct. So you don't dispute that they had an affinity relationship with him pre-divorce?
No, Your Honor. That part is undisputed. During the marriage of Patricia Podgorski to Ronald Podgorski, there was an affinity relationship between Ronald and Krista and Doug. However, Arizona law states that affinity relationships, being a legal relationship that arises out of marriage, is terminated upon the dissolution of the marriage out of which that relationship arises.
To follow up with that, help me understand how Arizona law makes that so clear that affinity terminates as soon as the marriage. I get it for a spouse. What about stepchildren? How does Arizona law clearly say affinity ends?
Your Honor, Groves v. State Farm is a case that this court decided, in which the court looked at a liability insurance contract, and there held that the divorce decree forever terminates the bonds of matrimony unless the parties remarry. And it actually uses the term legal relationship. And so we know that if the affinity relationship arises out of marriage, being a legal relationship, it also terminates upon the dissolution of that marriage.
So is affinity purely a legal relationship?
Yes, Your Honor, it is under the statute. And we know this because this court in Allen v. Sanders held that an affinity relationship arises out of marriage, and then in the Groves case that we just discussed, that it is a legal relationship and that the divorce decree forever terminates that relationship. Now, this is applying the plain language of the statute. And of course, the goal in statutory interpretation is always to give effect to the legislature's intent. So, first step in that analysis of statutory construction is looking at the plain language of the statute. If it's plain and unambiguous, then the court applies no further rules of construction and applies that term. Now, the Allen v. Sanders court found that applying ARS 1-213, technical words and phrases and those which have acquired a peculiar and appropriate meaning in the law shall be construed according to such peculiar and appropriate meaning. And as we've discussed, the Allen v. Sanders court found that affinity was just such a peculiar and appropriate term under the common law. Therefore, this court must apply that construction, that definition of the term, and find that the affinity relationship under 142804 terminates on divorce.
What if the decedent had written out what he perceived as supposed to be a legal document and simply said, I continue to enjoy an affinity relationship with what were my stepchildren?
Your Honor, any document that would be executed would have to be in writing. It sounds like the document you're contemplating would be. However, it must comply with the formalities required for whatever the instrument is required. So here it has to be some sort of a governing instrument that we're talking about that is going to either dispose of property upon death or that is going to convey with it a fiduciary nomination upon death. So
they have to have that position. They have to be in that position. There has to be a fixed, recognized legal position. Correct? I couldn't, for instance, say next door neighbor for 30 years, find out I'm dying and I leave him my pool table. Okay, can I do that unless I describe what the relationship is?
You could absolutely leave your neighbor your pool table. That would not involve a situation of affinity, and we're not dealing with divorce in that instance. Here we're talking about situations where two parties have been married, and during the course of that marriage or sometime pre-divorce, it could even predate the marriage, that the divorced spouse, as the term is used in the statute, designates the former spouse's children, in this instance, either to receive certain property upon the death of the decedent, so either through a will, a trust, or as is also the case here, a life insurance policy, then the two parties divorce. That is what terminates the affinity relationship. Now, there are certain instances where an affinity relationship could still exist between the divorced person and the former spouse's children after divorce. Now, that instance would be a situation, and it's described in the briefing, where, say for instance, Ronald had a son, and Ronald's son had, at some point prior to his divorce from Patricia, married Patricia's daughter, Krista. Then, even after the divorce between Ronald and Patricia, Ronald would still remain related to Krista by affinity because he would be Krista's father-in-law. So that's a situation where after divorce there would still be an affinity relationship. However, the relationship would not exist as a result of the marriage between Ronald and Patricia any longer as a result of their divorce.
So you can leave it to the child, you just can't leave it to the child in certain it's an affinity relationship.
Your Honor, I'm not sure I understand the question. I'm going to try to answer it and tell me if I'm off track.
Is the word affinity poison to a situation that other people may think you're just choosing to be generous in leaving something, disposing of, distributing, giving a percentage of an insurance policy?
Well, as long as there was no marriage, then there is going to be no revocation upon divorce. So we're only talking about, certainly if we're using the colloquial sense of the term affinity, I can choose to leave my property to whomever I want to. I can choose to leave it to my best friend, then I can go get married, and then I can get divorced, and my best friend is still going to take under my will, provided I don't otherwise change it, and it's a valid testamentary instrument. We check all the boxes, correct? So
only attorneys.
Only attorneys, yes. So it's only in situations where there has been a relationship that has arisen as a result of the marriage. And we're talking about affinity in that legal sense. So there's going to be no effect on my ability to leave property or to nominate someone as a fiduciary under any sort of governing instrument. I may do that. I can get divorced. It's not going to have any effect on that. The only time there's going to be an effect is when there is a relationship that arises out of the marriage. We think of it as the step relationships and the in-law relationships.
So I'd like to go back to the definition. Let's assume for argument's sake that the second affinity is removed, so that the sentence would read, I'll just read the last clause, that after the divorce or annulment is not related to the divorced person by blood or adoption, period. Wouldn't that make the legislative intent more clear? Much more clear here? Because the stepchildren would not be related by blood or adoption. It would clearly be, why would, I'm going back to my initial question, why did the legislature say, or affinity, if they didn't intend that there be some prospective application after the divorce?
Your Honor,
of the word affinity. Otherwise, to me, it becomes superfluous based upon the position you're advocating.
Your Honor, I think that it's not superfluous based on the hypothetical that I just presented, that there are situations where an affinity relationship could legitimately still consider or continue after divorce, and the legislature considered that there were such relationships.
But going back to Judge Jones' point, why do you even need that affinity relationship? Why do you need that in order to give your property to? Go back to your hypothetical. It's the father-in-law. It's the mother-in-law. No.
Under this hypothetical, if Ronald had a son who had married Patricia's daughter, Krista,
Okay.
then even after Ronald and Patricia divorced, Ronald would remain related to Krista by affinity because Ronald's son would still be married to Patricia's daughter. So Ronald would remain Krista's father-in-law.
Is there a case that bears that out? That
There,
type of hypothetical?
no, there is no case that bears out that hypothetical, but we do know, in looking at the legislature's intent, that in addition to looking at the plain language, that we also looked to the legislative history. Now here, ARS 142804 bears a substantial resemblance to the Uniform Probate Code Section 2804, including the use of the term affinity. And when a statute is based on a uniform act, then the legislature, or the court assumes that the legislature intended to adopt the construction placed on the act by its drafters, and commentary to any such uniform act is highly persuasive unless it's erroneous or contrary to the settled policy of this state. Well, if we look at the comments to UPC 2-804, there was actually a comment entitled Revoking Benefits of the Former Spouse's Relatives. And there, the drafters of the Uniform Probate Code explained that this section applies to a former spouse's relative. So in case we had any question whether or not it did, they say that it does apply, and they explain why. Because divorce has the effect of breaking down or weakening any former ties that may previously have developed between the transferor and the former spouse's relatives, and seldom where the transferor had favored retention of benefits. Now, the restatement third of property, wills and other donative transfers, in section 4.1 goes a step further. And in explaining revocation under UPC 2-804, uses the term children, which is the term that really gets us down to the nuts and bolts of this case. We're talking about former stepchildren here. And under the revised UPC, and this is from the restatement third of property, the alternative devised to, and they spoke of the hypothetical, but it would be to the former wife's children, is also revoked and passes as if the former wife's children had predeceased the decedent. So in looking at the legislative intent, we see that ARS 142804 is meant to apply to a former spouse's children. And it makes sense that it would apply to a former spouse's children. When we look at the legislative history, which has also been discussed by this court in, for instance, Lamparella, we know that there is an extension of the revocation and the idea that we'd want to revoke benefits to a former spouse. There's an extension of that to the former spouse's children because the same rationale applies. Now, it's not a draconian rule because there are ways to override the statute, but you have to do so in compliance with the formal requirements of 142804. There's very limited exceptions, and those exceptions are in the express terms of a governing instrument, in the express terms of a court order, or in the express terms of a contract related to marital property division. Those are the only three exceptions under which one could override ARS 142804. Now, there's another option, and an option that was available to the decedent here, and that was after the divorce, he could redesignate Krista and Doug as beneficiaries of his life insurance policy or as fiduciaries under his will.
Didn't he do that by writing checks every month?
Your Honor, that's extrinsic evidence of intent, and it is very clear from Lazar, which is the Ninth Circuit case that actually interprets ARS 142804. It's clear from that case that any...
Did Lazar involve stepchildren? It only involved an ex-spouse.
That's correct. The cases that we're dealing with involve former spouses. However...
Which is a lot easier question.
Your Honor, no, I don't think it is an easier question, respectfully, because
Well,
the
I mean, is there a case in the whole country that really addresses the issue that we have here?
No, Your Honor.
I mean, that's why I say it's a harder question, because we have clear case law on spouses. We don't have it on stepchildren.
But we have clear statutory language that says the statute applies to relatives of a divorced person's former spouse. And I'd like to reserve my remaining 2 minutes for rebuttal.
Sure.
Thank you.
Hold on just a second. Yeah, just hold on just a second. Yeah. Counsel.
Thank you. May it please the court, Kevin Parker for Krista Jones in her individual capacity. I'm going to split time with Mr. Collins, who represents Ms. Jones as in her fiduciary capacity as personal representative and trustee. First, to address the topic that your honors were speaking with counsel on, before we lose sight of the facts, the key fact in this case, we believe, is after the divorce, in the record, Ron got a new job, did a 401k beneficiary designation, and he had to describe Krista and Doug. He put Krista and Doug as the beneficiaries. He described them as his children. It is undisputed. He considered them his children. That's in the record, IR 35 at Exhibit 1A.
But counsel, isn't that extrinsic evidence? Like counsel was saying that anything outside the plain language of the statute is extrinsic. That would be extrinsic evidence.
Well, Your Honor, the statute doesn't actually say extrinsic evidence is disallowed. In fact, the statute is in Title 14, which the overriding purpose is to discover and make effective the intent of the decedent in the disposition of his property. Discover implies investigation and discovery and presentation of evidence. The overriding purpose is accomplished by presenting the evidence. You look at the date of death. What are the beneficiary designations? Do those still stand? Our argument is yes, absolutely. We disagree with the sort of brain teaser SAT question definition of affinity. We think the plain language. Affinity, he described them, the relationship by affinity using the plain language term of affinity. Absolutely, it is indisputable. And they don't deny that. Their argument is, you know what, we just got lucky, he messed up, he didn't intend us to have this, but we get it because of the statute. We just disagree with that, Your Honor.
What's wrong with their the interpretation that we ought to have, that the legislature intended a bright line rule as opposed to case by case? Because it seems like what you're advocating is it has to be looked on a case by case basis in order to discover the decedent's intent, and to see if that affinity relationship existed and to what extent. What they're advocating is, no, the legislature set a bright line rule here, and that's the best policy because the probate code and the uniform probate code is all about drawing lines, and this is a line drawn in the sand. What's wrong with that argument?
Well, I think in that case you would need to have plain language to tell the world this is how it's going to work. We don't have that. The case they cite for their definition, Allen v. Sanders, that's a criminal case. Allen v. Sanders says affinity is everywhere in the code. We have to look at the particular application here. Groves says usually this is what happens, but the courts have defined it in a number of ways. If there was a clear-cut definition of affinity, and then and it's used their term, and it was a bright line rule, absolutely, I would agree. But what's important about Allen, I think, is in its explanation of this term is used, affinities all over the place. It's in Allen, it's a criminal case, and it says affinity to the second degree. And it cites a footnote too, 10 other uses of it, affinity to the third degree, affinity to the fourth degree. That's a math exercise. Affinity, it doesn't surprise me that a court in those cases would use the marriage, because that is a math exercise. Marriage, first level, second level, third level. Our case is the probate code. It is affinity, it's a yes or no. It is not a degrees of affinity statute. And so, to the extent there's any ambiguity in the probate code, we think that you start with the overriding principles, find the intent. As cited in our brief, page 24 to 25, is the holographic will statute, where the court said, yes, this is exactly what it says, but our goal is to further the intent. And the holographic will statute says all material terms must be in the handwriting. But all that's in the handwriting is a name. Take out all the verbiage, and it's meaningless. And the court said, we're gonna kick back up to the overriding principles here is to further the intent. And so that was how the court addressed that definition.
So, counsel, let me understand your statutory interpretation. Are you suggesting, hinting, or do you think that the statute's definition of relative is ambiguous? Do you think it's clear? Do you think if it's ambiguous, then you're saying...
Well, it's either ambiguous or it's in our favor, Your Honor. To your points, it's why is it even there again unless it means what we think it means? That's sort of the practical point, and this is the textbook case. This is how you capture the intended beneficiaries, is with a practical definition. There's no one's even suggesting that Ron went and read the statute and researched the term affinity and came up with all these other conflicting cases. We're trying to, we have holographic wills.
He would be a genius if he did that.
Exactly. That's my point, Your Honors. And so we have a holographic will statute to implement the intent. People should be able to do it on their own. We have a very broad interpretation of the holographic will statute that says material terms. That's Arizona's goal, is to, if there's a way to do it without doing violation to the statute, implement the intent. And we believe there's a way to do it. And that is what we believe is the historical definition of affinity and the trend toward including stepchildren as members of the family. Divorce, one of the cases says, divorce, it may be a disagreement with the spouse. That doesn't mean anything about the stepchildren. But before I get too far afield on that, one of the two key points that I think we win the affinity issue, but on the insurance policy, that is the third argument. The first argument, which is the clearest and most, and I view as dispositive, is what the divorce decree says. The divorce decree and this speaks to the exceptions. We even get to the definition of affinity. I don't think we do. And that is because if you look at the divorce decree, well, the statutory exceptions are, if there's a divorce decree or a contract or the instrument speaks to what happens post-divorce, the statute doesn't apply. That's what controls. And here's what the divorce decree says. It speaks to this Zurich policy, life insurance. Each party has a term life insurance policy. Ron is awarded the life insurance policy, which names him as the respondent, and he may change the beneficiary designation thereof. So we have a divorce decree. Number one, it expressly references this insurance policy, the Zurich policy. And I'm focusing on this because this is the only asset. There are no other assets in the case. This is what the case is about, the Zurich policy. The divorce decree addresses the policy. It addresses the beneficiary designations under the policy. And it sets out the ground rules post-divorce. So it is a textbook exception to the statute. So the divorce decree should control over the statute. And that's the whole point of the statute. It's a default statute. It's a presumptive intent. If there's something else that tells you, then that controls over the statute. Our position is the plain English of the divorce decree says, Ron, you can change the beneficiary designations or you can keep the beneficiary designations. He kept them. The necessary plain English implication is if he keeps them, that will be honored. Their position is the court says you can change them or you can keep them, but if you keep them after you die, another court is going to change them for you. I don't believe that's a fair interpretation of the divorce decree. The divorce decree tells Ron, keep them or change them.
So are you suggesting we could decide the case solely based upon this argument?
Absolutely. Absolutely. You don't even get to the statute, so you don't even get to affinity. You don't even go there because the divorce decree, I'm sorry.
You're saying that fits the express, or you're saying it's just because it's in the court order, it doesn't need to be expressed, or you're saying it is expressed? I was a little
I'm saying it. I'm saying
it
it
is expressed.
Well, it expressly refers to the policy. It expressly refers to the beneficiary designations under the policy. And it expressly says you can change it if you want to, which the flip side of that in plain English is you don't have to. And so that's my inference. This is put yourself in Ron's shoes. What is this telling me? It's telling me I can change it, but I don't have to change it. And if I don't change it, that's going to be honored. I think that's a necessary implication of that language. To the contrary, is they're saying a necessary implication of that language is, yeah, you can change it or you can keep them the same, but if you don't reaffirm, then some other court later after you die is going to change them for you. I don't think that's an appropriate interpretation of the divorce decree. So we don't think the statute applies. But even if it does, we have an ex post reaffirmation, and that is 13 straight. So remember, the divorce court says you can change it or not, your choice. He does not change it. He knows he has not changed it. He knows he has kept them. It's a term policy. As a matter of law, it expires if you don't pay the premiums. He keeps the beneficiaries. He pays the premium in month 1, 2, 3, 4, 13, all the way through his death. There can't be any question that, at least in my view, that that's a reaffirmation of the beneficiary designations. The Uniform Probate Code comment that was referenced by counsel, if you look at the comment, it doesn't even talk about affinity. It basically just says, the statute says the divorced person's out and the relatives are out. It doesn't speak to the definition of relative. So the UPC comment is neutral in this case. If it said, here's the definition of affinity that we're going to use, and it's uniform code, and we expect every other state to essentially abide by this. We're going to have clarity. We're going to emphasize clarity over intent. They could have said that in the comment. They didn't. And they don't need to repeat, the drafters of the code don't need to repeat in every subsection. Remember, keep in mind, this is to be interpreted to discover and make effective the intent of the decedent. So I think the overlay to that comment needs to be the overriding principle of the code. The Uniform Probate Code section, that section does not say the word affinity in it at all. A couple cases before I turn it over to my Mr. Collins. They've cited the Lamparella case as supporting them. We think the Lamparella case supports us. The court in Lamparella says the divorce decree in that case did not refer to the annuity. Our case, it refers to the policy. That case, Lamparella, is a single payment annuity. That single payment is before the divorce. Our case, we have 13 months of reaffirmation of the designations. Lamparella also says extrinsic evidence is admissible. It cites to the extrinsic evidence of the decedent's intent. That's consistent with 141102. Is what we're really trying to do here is not play these little word games. We're trying to divine the intent of this person and implement that intent. So let's use all the tools we can to figure that out. Lamparella says extrinsic evidence is admissible. It discusses the extrinsic evidence. Unless you have any questions, Your Honors, I will return it over to Mr. Collins.
No, thank you.
Thank you.
Go ahead. Mr. Collins, hold on just a second. Please proceed.
May it please the Court, I'm Craig Collins. I represent the personal representative, Krista Jones. I don't agree that Arizona law is clear that a divorce terminates the affinity relationship. Counsel cites the Groves case. The Groves case did not even involve an affinity relationship. Allen defines affinity as a relationship that one spouse has with the blood relatives of the other spouse. In Groves, we have an in-law, not a stepchild. Affinity was not the issue in that case. The definition of relative was the issue, and it limited it to marriage and blood. Nothing about affinity. The hypotheticals that counsel raises in terms of these affinity concepts go way beyond that permitted by the Allen case. When you look at the Allen case, as I just recited its definition of affinity, it also says clearly that affinity is not the blood relationship of one spouse's blood relatives with the blood relatives of the other. Once you get into that, you've got affinity coming out of the walls. In 2016, in the Michigan case, which I have not had a chance to cite, but it's Lewis versus Farmers Insurance Exchange, there's a good discussion upon the expansion of affinity beyond that, which is what permitted in the Allen case. Now, I refer to the Allen case. It's not referred to in the Michigan case, but it does talk about these expanded notions of affinity. We're dealing here with the affinity relationship between the decedent and his two stepchildren. Krista's position all the way through this as personal representative has been that 2804A does not apply because she and Doug are not relatives of the divorced person's former spouse as defined in 2804I5. The inclusion of the word affinity in that statute evidences a legislative intent to benefit step relatives and in-laws. The Bordeaux case, 1950, 70 years old, was talking about the modern tendency being to assimilate the stepchild to the natural child. Here we are 70 years later, and I submit that is more of a tendency now than ever. We talked about extrinsic evidence a little bit. I agree that the exception part of 2804A does not really allow for extrinsic evidence. But how do you define whether a person is a relative of a divorced person's former spouse by way of affinity unless there's some extrinsic evidence that you look at? We have 14 days after the divorce, the email that the decedent wrote to his close friend Jerry Joyce and a handful of other friends, where he stated that the divorce is not going to change his relationship with Krista and Doug, that he loves them dearly, and they're always going to be his children. I encourage you to read that email. So I think extrinsic evidence can be utilized in determining whether a person is related under 2804I5 by way of affinity. I wanted to talk just briefly about the attorney's fees that we've asked for. Ms. Jones was the nominee in the decedent's will. She's been appointed as the personal representative. She has withstood 2 objections at the trial level to have her removed, successful in summary judgment proceedings. She's acting in good faith, and I submit pursuant to this court's standards in the Killen case and the Gordon case that she has furthered, the litigation has furthered a directive of the decedent as expressed in his will, and that she is entitled to attorney's fees. I really don't think I have anything else unless the court has any questions.
Thank you, counsel.
Thank you.
Thomas, if you'll hold on for a second.
Lamparella does not say extrinsic evidence is admissible under 142804. The section of that opinion that discusses the use of extrinsic evidence is in respect to Title 25, and it's 25.318. It's the interpretation of a marital property settlement agreement and the application of the parole evidence rule. The court was generally citing the parole evidence rule and its admissibility in certain instances, but not when it would vary or contradict the plain language of a contract. Arizona's interest, and I'm quoting here from Lazar v. Kroenke, Arizona's interest in its revocation on divorce statute is not merely to effectuate a donor's probable intent, but also to provide clarity and avoid litigation. Even the statutory exception demonstrates this desire for clarity, because doing so requires either an express provision ex ante that the designation will apply in the event of divorce, or an ex post reaffirmation. Here, we have no express provisions that were entered into either before or at the time of divorce. You've heard from Mr. Parker that there are express terms in the consent decree in this matter, and that's not the case. We know from Lazar that any express term removing an instrument from the scope of the revocation on divorce statute must address the effect of divorce on the disposition or nomination. That does not exist in the consent decree in this matter. The express provision must state that the designation will apply in the event of divorce. A designation saying that a party may change a beneficiary. I see that I am out of time. May I finish my point?
Yes,
a designation stating that, or a provision stating that a divorced person may change a beneficiary designation does not address the effect of divorce. In other words, well, what happens if he doesn't? It's a cliffhanger, and we don't know. So the consent decree is actually silent as to the effect of divorce, and Lazar states that silence is not enough to satisfy the express terms requirement of the revocation on divorce statute. Thank you.
Counsel, thank you both for your arguments this morning. Court will take this matter under advisement and issue a decision in due course. Court is going to take a brief recess to prepare for the next argument. Thank you.